Shop now on KarmaloopTV and get free shipping on any order. Just use the promo code Chelsea.
This is the second segment of our three-part series on the issue of marriage equality in the U.S. As we mentioned in the first segment, gay marriage is legal in only 5 states: Connecticut, Iowa, Massachusetts, New Hampshire, and Vermont, and in Washington, D.C., which is a district, the District of Columbia. The issue can be pretty confusing. You hear about one state doing one thing, another state doing another. You see rallies and signs and hear information and misinformation. So we thought we'd lay out some facts to try to paint a more coherent picture of what the heck is going on. For this segment, we want to start in 1996 with the Defense of Marriage Act, or the DOMA. This could be a joke, but I'm not making it. The Defense of Marriage Act prohibits the federal government from recognizing same-sex marriage by explicitly defining marriage as a union of one man and one woman. Before the DOMA was passed, the federal government didn't have a definition of marriage, so any marriage that was recognized by a state was recognized by the federal government, even if it wasn't recognized by other states. For instance, until 1967, a lot of states in the US had anti-miscegenation laws, which means no interracial marriage. Yes, for real. Still, because the federal government didn't explicitly define marriages between two people of the same race, an interracial marriage made in a state where it was legal, say Pennsylvania, would be recognized by the federal government even if it wouldn't be recognized by a neighboring state like Virginia. As it happened, in a 1967 case called Loving v. Virginia, the Supreme Court declared anti-miscegenation laws to be unconstitutional. Once the court handed down this decision, no states could make interracial marriages illegal. We believe that one day the U.S. Supreme Court is going to do the same thing with respect to same-sex marriage, make it a constitutionally guaranteed right and not let states choose whether they want to allow it or not. So to recap, before the DOMA was passed, if one state had recognized gay marriage, the federal government would have recognized it too. However, now that the DOMA is in place, the federal government is prohibited from recognizing any same-sex marriage anywhere. You might ask, whatever brought the DOMA about anyway? And I might say, Hawaiian conservatives. Some legal rumblings in Hawaii, which didn't even end up leading to same-sex marriage, put the fear of a gay-hating, wrathful God into the heart of conservatives throughout the land who saw the makings of gay madness.
It's alive! It's alive! It's alive! It's alive!
They decided that a federal law was needed to protect the sanctity of marriage and started advocating for the DOMA. Congress passed the DOMA, and it was signed into law by then-President Bill Clinton, who we all know truly believes in the sanctity of marriage and takes his vows very, very seriously. As a side note, Bill Clinton has since stated that his position was wrong.
In fact, it was wrong.
His position on the DOMA, that is. And if the meanness of the DOMA weren't enough, opponents of same-sex marriage, or as we like to call them, rude jerks, have gone so far as trying to amend the Constitution to define marriage as a union between one man and one woman. The constitutional amendment issue has also been brought up in many states on a state constitutional level, and it's not been good for those who believe in equal treatment and non-discrimination. Most states have something, whether just the state law or, to really seal the deal, a state law plus a state constitutional amendment that bans recognition of marriages between same-sex couples. Many of these states have no form of relationship recognition in their laws, so no rights, although a few do have some of the rights and responsibilities of marriage in varying degrees depending on the state. Let's lay it out. These are the states that explicitly ban the recognition of same-sex marriage and offer no forms of relationship recognition for same-sex couples. So if you're a same-sex couple living in one of these, you're getting Zippo. These are the states that explicitly ban the recognition of same-sex marriage but do offer some of the rights and benefits of marriage under their domestic partnership registration statutes, which vary from state to state. California, Colorado, Hawaii, Nevada, Oregon, Washington State, and Wisconsin. Then there are the states that do not explicitly ban or even address gay marriage and do offer some of the rights and benefits of marriage under their domestic partnership registration statutes, which vary from state to state. Maine, Maryland, New Jersey, New Mexico, New York, and Rhode Island. These are the ones to watch because they're not aggressively stamping out the concept, just not actively allowing it. Just to clarify though, even if gay couples can get rights under state law, they're still unable to get federal rights accorded to married couples. And anyways, it's not just about rights, it's about love. Then there's the awesome states. Massachusetts, which was the first state to extend the right to marry, Connecticut, Iowa, New Hampshire, and Vermont. And the District of Columbia, where a marriage equality measure was recently passed by the District Council and signed by DC Mayor Adrian Fenty on December 18, 2009 in the All Souls Church, a Unitarian Universalist house of worship. At the signing, Fenty, who was joined by his interracial parents, said, we've set the tone for other jurisdictions to follow in creating an open and inclusive city. By the way, DC's Marion Barry voted against the bill. So he's pro-crack and prostitutes, but against gay marriage. That, friends, is called nerve. So now we've touched on all the states, but we want to focus a little on the latest 4 setbacks for marriage equality: California, Maine, New Jersey, and New York. The Golden State received a ton of news coverage around Prop 8, which some prefer to call by its more descriptive name. No, not the California Marriage Protection Act, but Prop 8. Here's the breakdown. Thanks to a ruling by its state Supreme Court in May 2008, California recognized gay marriage. This recognition lasted about 6 months, and then Prop 8 came along. Prop 8 was a ballot proposition passed by California voters, which amended the state constitution to restrict the definition of marriage to one between a man and a woman, thereby overturning the existing law that made same-sex marriage legal. The approximately 18,000 marriages that were performed in California do remain valid, except that if those couples divorced, they wouldn't be able to remarry. And on October 12, 2009, Governor Schwarzenegger signed a bill recognizing same-sex marriages from other states or countries that were performed on or before November 4, 2008. A similar, though less well-publicized thing happened in Maine, where in May of 2009, the legislature passed a bill legalizing gay marriage, but then in November of 2009, the people of Maine rejected it in a popular referendum. In December of 2009, the New York State Senate voted down a Governor Patterson and Mayor Bloomberg-supported proposal to legalize same-sex marriage. Supporters of the bill said they felt betrayed by some of the Democratic senators who said they would vote yes, but then they chickened out. And a few Republicans were also meant to vote yes, but in the end, they too chickened out.
These aren't even birds. I am not afraid. That's enough.
And in the latest development on this front, on January 8, 2010, a marriage equality bill was defeated in the New Jersey State Senate. However, marriage equality campaigners are planning to take the issue to the state Supreme Court. So yes, there have been setbacks. But this issue is not going away, and the biggest news is the teaming up of former Bush v. Gore rivals, Ted Olson and David Boies, to overturn Prop 8 in federal court. The conservative Ted Olson, who was Solicitor General under the Bush administration, had this to say to Margaret Talbot of The New Yorker. The Loving case was 42 years ago. It's inconceivable to us these days to say that a couple of a different racial background can't get married. Separate is not equal. Civil unions and domestic partnerships are not the same as marriage. He added that he saw the case as a teaching opportunity, so people will listen to us talk about the importance of treating people with dignity and respect and equality and affection and love, and to stop discriminating against people on the basis of sexual orientation. The case is likely to go on to the US Supreme Court, whose ruling would affect the whole country. But first, the federal case has to finish, so we've got a little while to wait. Gay marriage is a matter of equality under the law, and like many discriminatory practices before, this discrimination too will be corrected. If you don't want to feel like a dumbass later, you should be supporting it now. Speaking of dumbasses, if you want to see some glorious hypocrisy in action, check out our last segment in this series called Big Fat Hypocrites.